Companies Act. A special presentation by The Firm.
29 chapters, 470 sections, 7 schedules. The rules of the game have changed for each of India's 9,44,000 companies. Say hello to the Companies Act 2013. Hello and welcome to this brand new series brought to you by The Firm. Over the next many weeks, we will analyse the impact of the new company law on incorporation, capital raising, governance, board management, accounting and audit, M&A, litigation and bankruptcy. On this very first episode, though, we start by giving you the big picture view on how life has changed for companies, their management, their boards, auditors and their shareholders. And to do that, I have with me an expert panel of Bharat Vasani, Cyril Shroff, Jamil, Khatri and D. Muthukumaran. Gentlemen, to all four of you, a very warm welcome. On 31st May 2005, the J.J. Irani Committee, the original architect of this new law, submitted its report saying, "Our effort has also been aimed at making India globally competitive in attracting investments from abroad by suggesting systems in the Indian corporate environment which are transparent, simple and globally acceptable." The committee advocated that it be a simplified, compact law, amenable to clear interpretation, and that it should enable protection of the interests of the investors and other stakeholders. Does the Companies Act 2013 meet these criteria? Amarchand Mangaldas managing partner Cyril Shroff says it's a mixed outcome.
I think we've moved away from a shareholder model to a stakeholder model. I think the Act has been made very compliance oriented, a reflection of a deep distrust of corporate India. I think the doing business in India difficulty factor has gone up. It has changed a lot of power equations as well, particularly between the majority and the minority. We do make some progress, particularly on M&A or capital raising. I think some of those objectives have been achieved.
Tata Group General Counsel Bharat Vasani has two key grouses: that the new law attempts to transplant a Western model of investor rights in India, but more importantly, that its implementation has been anything but smooth.
The new law was in the offing for the last 10 years. They didn't give me much time to digest the rules. There's one fine point which everybody is missing. You know, the section 465, which says that the 56 Act is repealed, has not been even notified as yet. Many of the rules are completely going beyond the Act, and people are now confused whether they should comply with the Act or the rules. Loans and investments and guarantees by holding company to its wholly owned subsidiary, which was completely exempt under 56 Act, was taken away in the Act.
Right.
It was taken away by conscious debate. Twice it was referred to the Parliamentary Standing Committee. They were very firm. It was based on a specific recommendations of a joint parliamentary committee which was investigating Ketan Parekh scam, that these layers of subsidiary and diversion of funds of the holding company through the subsidiary should not be allowed. Fine. Now they realized that India Inc. had a very strong protest, but this should have been done through a power to exempt under section 462. They have just framed a rule which says that now holding to subsidiary will not be considered. They have invoked 3 times already a section called power to remove difficulties. This is absolutely like a Brahmastra. You know, it's a executive changing the act of parliament. Internationally, it's called Henry VIII clause. It's very rarely you should do rarest of rare cases. Here, within few days of notifying the new act, we had to use it 3 times, and I don't know how many more times they have to use it.
The Aditya Birla Group corporate finance head D. Muthukumaran laments the higher burden of compliance.
There are a lot of changes on compliance aspect for a company. These are dramatic changes. Bigger theme that seems to be coming out to me from this act is basically around all aspects of corporate governance. There are lots of other, sort of conceptual changes. For example, you can only have 2 layers of companies. You can only, there is a concept of reverse merger that, sort of he spoke about. There is also, big impact on definition change of subsidiary. The short way of putting it, I think, is there are a lot of probably painful changes on the compliance aspect of it. On the concept aspect of it, I've not seen anything which is, significantly painful.
KPMG's Deputy Head of Audit, Jamil Khatri, is more welcoming of the new law's focus on better governance.
When I talk to my institutional investor clients, they're very happy with what's happening. Right from the basic points on accounting and reporting, where they've removed, areas where you could directly, hide losses in reserves and not use your P&L. to having an internal control framework that is aligned to what we see internationally. I think we are moving in the right direction on that. We have overreached on some of the issues, particularly bringing in unlisted companies into the purview of governance.
What I would like to do on this show is to look at this from the point of view of different aspects of corporate life and see what has changed for those people. So I'll start with you first, Mr. Shroff, from a CEO, CFO, senior management point of view, and hence if I can call it from the company point of view, what has changed in terms of being able to incorporate, being able to grow and innovate, raise funds, merge, acquire? Do you see a dramatic shift? What would you identify as some of the 2-3 big areas? For instance, private placement and the relaxation of the 50 limit to 200 might qualify as one big area, you know.
Yeah. So just 3 or 4 big points, because this can be a longish discussion.
Sure.
Coming back to some of the high level points, I think ease of doing business reduced significantly. The difficulty factors got added. M&A scenario, I would sort of give it a 5 on 10, because some things have improved a lot, others is work in progress. For instance, wholly owned subsidiary merger, house mergers in a manner of speaking have become much easier. The level of cantankerous objections that can be raised in a court in a scheme of that, the threshold has been set high enough to eliminating some of that. So both good and bad news. I think from a structuring point of view, because of a number of small changes that have been made, I think it's got a lot more difficult, like the subsidiary example that he mentioned, or in private placements having a floor valuation. Some of this may be unintended consequences of disconnected changes, but the level of difficulty in structuring transactions, whether they're M&A or funding or any kind of partnering transactions, has gone up. So that's a challenge. And I think whilst another sort of core provision has yet to come into force, I think the whole class action thing, which is sort of looming on the horizon, and when it becomes effective, is going to be a fundamental change in terms of how corporates look at liability and look at stakes. So it's going to be more US style, where people become much more cautious, not because of regulatory compliance and policing by regulators, but what they might have to face in terms of lawsuits, which may be filed. I think that is going to be a huge change when that comes in.
When that comes in. When that comes in.
When that comes. It will come,
What would you all like to add to the list that Mr. Shroff has already drawn up?
Yeah, I think more than any of the things that you listed, whether it is incorporation or it is M&A or it is fundraising, innovation. I think the challenges for a CEO and a CFO now under the New Companies Act is more on actually managing on a day-to-day, year-to-year disclosure, accounting, compliance basis.
Okay.
I think it's a lot more complicated to get, for example, the kind of directors that they're talking about, the responsibilities. For example, there is a definition on the kind of internal control system that needs to be put in place, which the CEO and CFO needs to certify. It is really, really wide. And the way I understand, it's wider than what is there in the IFRS. IFRS talks about internal control system on financial reporting, whereas this talks about...
I think the rules somewhere link it to financial statements, but the Act doesn't do that as yet, and that's still a grey area.
So if you have to go by what we heard before, Act overrides rule.
Act overrides rule.
So,
And I think, sorry, just on that point, I think the Act is clear that for listed companies, it will be a much wider kind of framework. The rules address unlisted companies. So any relief is actually an unlisted company relief, and
not a listed company relief.
Yeah, so to that extent, on a day-to-day management basis of the company, there's going to be a lot more complications than, sort of what was there in the past. How do you define whether you have appropriate level of internal control systems for non-financial reporting matters? For example, it talks about protection of assets, protection of property. There's a proper system on avoidance and detection of fraud. So, I think these are, noble, unchallengeable intentions, but I think,
But complicated, painful ones to deal with.
I tell you, CEO, CFO, and I would like to, if you permit me, enlarge it to also directors. There is a perceptible change, there's a perception change that suddenly our liabilities have gone up. In the board meetings where I go, suddenly they've said from 1st of April that I have become now more liable. Are we more accountable?
Even though the liabilities under the Act have been circumscribed?
Liabilities under the Act has not been circumscribed, they've just codified it. In fact, everything is got codified, which was earlier there at common law.
But haven't they said that independent directors are guilty only if
sorry, I don't think it's only under the Companies Act. So it's a very limited field, 25,000 fine or something. The general liability under all other law is still very much
But
the
how
same.
can the Companies Act take away liability under other laws?
Precisely, but so the general feeling that now I'm immune from any criminal prosecution, that's not correct.
But that existed before and that continues.
The fact remains that certain things which are like, for example, the disclosure standards, they've gone up to such a high level that I don't know, people have really gone through what is required to be disclosed in the director's report or the annual return or many other filings they have to do. It's unbelievable. For example, half of the corporate India even today don't know that from 1st of April, the disclosures which you have to do as a directorship is now required to be filed with the register of companies. And any changes in your shareholding, which was never the case earlier.
Has to be filed with the ROC.
Sure. So many of those things have happened, and the number of things which you are required to do at the board meeting. For example, many of the things which CEO could do earlier, from CEO's perspective or CFO's perspective, they are now required to be done mandatorily at the board meeting.
I think the board and the audit committee particularly will get more involved, would need to get more involved on transactions which they previously relied on management. So for example, internal controls, the audit committee needing to kind of review the internal control certification by the management and kind of agreeing to that. Related party transactions, getting assessed by the audit committee for being at arm's length in the ordinary course of business to make the determination on whether they need to go to the shareholders. Auditor appointment and the non-audit services being kind of provided by the auditors. I think the audit committee would need to step back and really kind of figure out how they are going to implement this. Okay. And in my experience, this also has an impact on how management deals with the audit committee and some of the dynamics around that.
What would change that?
So for example, previously, management would have presented a lot of information to the audit committee, but it turns out to be more for your information kind of a thing. While now audit committees, because they are responsible, would like to get involved into the rationale a lot more. Okay. And I think that's going to change.
That's a good thing, isn't it?
And so I'm not necessarily, remember I started by saying my institutional clients love it. And therefore I think it's about getting used to it.
Just to supplement what Mr. Khatri has said, one of the concerns which all audit committees have expressed to me is that how do they determine whether the transaction is at an arm's length basis? And Companies Act is not providing any guidance much. They may look at income tax provisions of transfer pricing and decide, but the larger issue which I see now, that most of the audit committees would like to play safe.
Sure.
They've been empowered to take independent consultants' advice, so I would assume that the accounting firms and lawyers firms would have a much more job to do, because most of the independent directors would prefer that they have an external certification that the transaction is
at arm's length.
And that would only lead to, so that would lead to a frequent external consultation by the audit committee. And the worst part, Cyril, is that 177, which deals with the duties of audit committee or the role of the audit committee, is much wider than 188, which deals with related party transactions. So it requires prior approval. So in practical terms, we were evaluating in our group and we have prepared almost a manual on related party transactions. I find it very difficult that how do you in every case get a prior approval of the audit committee? Means almost every week you have to have a meeting of the audit committee. Can it be done by circular resolution? How do you bring audit committees to the board? Because every transaction which is a related party transaction, the way it has gone, so I don't know how are they going to handle it.
Eventually when you sit back and ask yourself the question, has it resulted in better governance or not, you may not always get the answer
yes. Okay.
Yeah. But it certainly has benefited the accounting community and the lawyers community that there will be far more references, and next couple of years this country is going to be run by legal opinions.
Companies Act, a special presentation by The Firm.
I think the last viewpoint that I wanted to bring onto this table is looking at it from the point of view of promoters and thereby converse minority shareholders. And clearly, as all of you have said in your opening comments, the shift in balance of powers has taken place there because minority shareholders have been empowered in many instances by this act to make their voice heard, whether it is the approval of related party transactions or asking for exits in the case of a change in objects and clauses, etc. How would you look at how that relationship has changed? And let me put a question to you that I know you've been putting to many of your clients and associates. Is minority the new majority today?
On some of the things, yes, it is, because the decision-making authority on certain things has now moved to the minority. But actually, on a broader note, I see a certain element of legislative and regulatory schizophrenia here. The reason I say this is that on a number of things, you're telling the promoter or the controlling shareholder that particularly when you list and you go to the public markets, that you're now like every other shareholder. You have no special privileges. You will not take control premium. You will not do that. So you are at least as far as your rights are concerned, you are like everybody else, you are a citizen with equal rights. But then when you sort of come into a regime like this and you take out this constituency, namely the promoter or the controlling shareholder, say no, but apart from being equal as far as your rights are concerned, here is a long list of additional roles, responsibilities and liabilities that you have. So I don't think that equation is completely fair. So for instance, in terms of responsibility, say in minority exits, or put options on them, or the kind of additional burdens that I think they will carry has changed the power equation as well. I think it has changed the burden equation as well.
Yeah.
I think that's now whether that is justified because of the enormous power that promoters have and therefore it's sort of like a compensating regulatory feature. One can have that debate, but that is the equation I think that has changed, and that is probably wherein the mindsets of a number of promoters who have lived in a very different regime for so long will have to come to terms with this new reality. I think
I
it's
have
going
a
to
big
take
smile on my face, sir, because I think the activist in me concedes that some of this may be unviable, difficult to implement and all of that, but it clearly pushes us to a new era of governance, doesn't it?
This is probably
It's
the
a
biggest
fundamental
piece.
change.
This is the biggest piece,
This is
right?
the
It's the biggest piece. It's a fundamental change. There's a paradigm shift.
Yes.
But there's an angle which I'm sure there's no final word has not been said on this, because there may be some majority shareholder who says that now you're putting all the obligations on me, and my basic right, when I buy 51% shares in the company, I have that's my right to property. That's basically right to receive dividend or right to vote. You are taking away my right to vote. And it's a right which is constitutionally guaranteed.
Only in related party transactions.
Yeah, but
only in related party transactions.
But
only if the promoter is involved in that transaction. It's in a very narrow set of cases. And let's admit, those narrow set of cases have been full of abuse in the last so many years. Full of abuse. That had to be halted.
But if I can just sort of add, just from a purist perspective, that fiduciary roles and responsibilities always attached to directors and boards. A shareholder was entitled to act as selfishly as he wanted because of the same theory. That
so how is this putting a fiduciary
you could have dealt with it.
responsibility?
It does, because it effectively creates. How do you disenfranchise somebody from voting? Because of a conflict of interest. Why do you say that the majority will not vote? Implicitly because of a conflict of interest.
If a director is the interested party in the board meeting, the director cannot vote. If the promoter is an interested party in a general meeting, the promoter cannot vote as well.
No, I can't argue.
We are looking at conflict of interest here, and wherever you are conflicted, you are not allowed to be part of the decision making.
I am not opposed to this move, but I would say fundamentally, as a purist perspective, as Cyril pointed out, there's enough of literature in the international legal circles which suggests that shareholders owe no fiduciary duty.
But why
and they are
would
supposed
you
to
say
act
this is
in
a
their
fiduciary duty?
Of course, it's
this is a removal of conflict.
The board is
isn't it?
prevented. The board is prevented from voting because board is acting in a fiduciary capacity for somebody else.
You could have dealt
shareholder
with
is
it by
supposed to act in his
disclosure
best
regime.
interest. And
So he should be allowed to cast a vote in his favor.
In his favor.
With proper disclosure.
And they tried it in England in 1985 in Companies Act, but they didn't succeed. So they brought it back in 2006 Act that the majority can vote.
Again, this is behind us, so let's not debate it as in good or bad. But I think this is what I think from an impact perspective is going to be the single biggest implication for controlling shareholders.
I think from the way I see this is, if you already have a provision which says if something is on an arm's length and in the ordinary course of business as determined by the audit committee you don't have to go to the shareholders. And I think therefore this is seeking to as an anti-abuse provision. If something is not arm's length and not in the ordinary course of business, I think legal points have been well made.
Jamil.
But what this will do in my mind is make sure that transactions with related parties go through the arm's length and the ordinary course of business assessment, which is with the audit committee.
Right.
And I don't think that's necessarily a bad thing, in terms of
One negative fallout could be green mail by small shareholders. I mean, that is going to happen.
Or proxy advisory firms.
Yeah, I think it sort of goes as a package.
I find it hard to actually challenge this provision. Conceptually, to say that somebody who is actually conflicted should not vote in a resolution is a right provision.
So you're in my corner.
Yeah, I know.
corners do you have?
I only one corner. On this point, this is the only corner.
Yeah, but I think what I find it hard is the point that you last mentioned, which is actually is there going to be a green mailing issue? Is there going to be I'll give you an example.
Okay, so
delisting provision. Delisting provision in India is
reverse book building.
Yeah, reverse book building, delisting through reverse book building, I would argue has been reasonably, sort of misused by the minority shareholders against many, for example, international companies.
But look, I mean, there was a time when a single shareholder could hold up a scheme for months. Now they've gone the other extreme and said, look, if you don't own 10%, you can't make an objection at all in the scheme. So I'm not sure that,
that's only one single provision which has gone against the minority shareholders. I think the 10% threshold is pretty high.
And I think it's gone incorrectly against them.
Very high, very high.
Who has 10%? Even a mutual fund or an institutional investor would find it difficult then to object to a scheme.
I don't know how the tribunal will deal with it in the past. We have seen the experiences.
We have to see all that.
Yeah.
So we're pretty much at the end of our time. There are several other issues to talk about. I think CSR is a whole new concept in this Act. We'll probably touch upon it in future episodes. Mr. Vasani has already touched upon the rules and the overreach, so to speak. The impact on private companies. I mean, that's the subject matter of another half-hour discussion because they've been brought into this Act, and I think some of you have already referred to that in some way. Jurisprudence, the old Act, all the case law that you have, what happens to the concepts in the new Act? How do you work through that?
No, I think there's some guidance available in the sense that it's what they called, if you see the preamble of the Act, it's a consolidating and amending Act, and there are Supreme Court judgments to suggest that when it's a consolidating and amending Act, unless the provisions are identical, the old jurisprudence does not hold valid. The problem I have is some of the landmark judgments of the Supreme Court, whether it was on that Mihir Mafatlal versus Mafatlal Industries, that in a merger scheme, the court is only having supervisory jurisdiction and not an appellate jurisdiction, whether it will hold valid for NCLT because the provisions are not pari materia, they are significantly different. Okay. So that is the worry. See, this company is at one area where they could have done it, that some of the important principles of law which Supreme Court laid down in some of the landmark judgments have not been codified. Whenever you are revising a statute, normally you do that. That has not been done. So many, like Needle Industries judgment on Section 81 rights issue, not codified. So many of these things will come to haunt us. Only time will tell how the courts will interpret it. But the old judgments, unless they are absolutely identical provisions, will not be helpful to us under the new.
All right, gentlemen. On that note, thank you to all four of you for joining us on this very first episode of this brand new series. Next week on Companies Act, we'll be discussing chapters 2, 7 and 13.
Companies Act, a special presentation by The Firm.